Well, good evening, everybody, and thank you for coming along to this CPD session. I'm Richard Cheney. I'm one of the barristers here at Greenway, and perhaps contrary to the perhaps misleading advertising of tonight's event, I'm the mere chair here tonight. All the brains work has been done by the fellow to my right, Garth Campbell, who's been a member of Greenway for a couple of years now and has practiced in construction law for about 15 odd years, I think, at least.
Yeah, a bit more than that. Yeah.
A bit more, including 3 years at in-house at Land Lease, and has practiced almost exclusively in this area for all the time that he's been a lawyer. He's also a past editor of the Australian Construction Law Bulletin. So we couldn't have a better jockey than Garth for tonight's talk. The format is to take a sort of a staged approach. I think the plan is to speak about, briefly at least, about the development of the common law concepts of pure economic loss as they're established by the authorities, and then discuss briefly the events that led to the passage of the Design and Building Practitioners Act, and then to look at some of the authorities that have considered Section 37 of the Act, in particular, the what's caught by the and who is caught by the statutory duty of care that it establishes, and the implications of those authorities. There's also, I think, Garth's going to talk about the proportionate liability provisions as they're dealt with by the Act, and I think give some advice about pleading and defending a claim under the Act, which is perhaps what we're all most interested in. So without further ado, I might hand over to Garth.
Thanks, Richard. So the title of this presentation is Be Careful What You Wish For. And the reason for that is because it's a bit of a cautionary tale, and there are some pitfalls that you can fall into when pleading a claim for under Section 37 of the Design and Building Practitioners Act. So I'll go through firstly the history of why the Act came to being, and then how to do it and what to look out for. So Section 37, as you're probably all aware, is a duty of care provision. It imposes a duty of care on a person who carries out construction work. And then the duty of care is to exercise reasonable care to avoid economic loss caused by defects. So the fact that it's a duty of care provision is important, and also the fact that it's owed to the owner and the subsequent owners of land. And it's important to consider it's a duty of care provision when you look at negligence as a whole, because this provision is supposed to fit in with the law of negligence as a whole. So what are the basic elements of a claim in negligence? Well, you've got the existence of the duty of care and its scope, which is what we're mainly dealing with Section 37. But then you've also got a breach of the duty itself, and the damage or the remoteness of the damage, the causation element, thirdly. So these are the three elements that we have to deal with. And Section 37 was designed to fix a particular issue, being the issue with the duty of care. So historically, there's no general test for determining the existence of a duty of care in negligence. It will always depend on the facts of the case itself. The courts have used some concepts like proximity and reasonable foreseeability to determine whether or not a duty of care exists. But there's no hard and fast rule, and you have to look at the facts of each case in particular. And also historically, duties of care were imposed on people who followed a calling which required skill and competence to exercise in the calling such reasonable skill and competence as was appropriate. So that led to the impositions of duties of care onto practitioners like medical practitioners, solicitors, engineers, those sorts of people. And the development of the law of negligence was the development of different classes of relationships between the person who owed the duty and the person who suffered the damage. And that's where the concepts of proximity and reasonable foreseeability came into play. So that's the historical nature of negligence as a whole. But then we have pure economic loss. Now, pure economic loss is defined to be economic loss which is not consequential upon injury to a personal property. And by injury, we're talking physical injury. So construction defects are considered to be pure economic loss because a construction defect is constructed into the building itself. There's no tower falling over that causes a construction defect. It's actually built into the property. And in that sense, it's a pure economic loss to the owner of the property. The difference between what they're expecting and what they actually got. That's the defect, and it's an economic loss because of this definition. Another form of economic loss is loss consequent to injury to a third party. So if there's a physical injury to a third party that causes a party loss, so if party A causes an injury to party B, and that injury causes party C loss, well, party C's loss is purely economic. And there was a general rule established in a case in 1875 of Cattle and Stockton Waterworks that pure economic loss could not be claimed in negligence. And that was the way that the law was up until, in Australia at least, 1976. In the UK it was 1964. So in 1976, we got this case, the Dredge Willemstad. It's a very famous case. And it's famous because it's the first time the High Court in Australia awarded a claim in negligence for pure economic loss. Now, the facts of the Dredge Willemstad were that there's an oil refinery that was operated by Australian Oil Refinery, OAR, and that was at Kurnell on one headland of Botany Bay, and the Caltex oil terminal was on the other. The oil refinery and the pipeline were owned by OAR, and the terminal was owned by Caltex. The oil in the pipeline itself was also owned by OAR. Now, the risk of the damage to the pipeline was with OAR. Sorry, the oil in the pipeline was owned by Caltex. The risk of damage to the pipeline was with OAR, the owner of the pipeline. That was as a contractual arrangement, and by the fact it owned the pipe itself. Now, the Dredge Willemstad came along, dredged the bay, and cut the pipeline. So what we had here was a situation where Caltex was losing money because its oil was flowing through the pipeline. It was losing the oil, but the damage was caused to OAR's pipe. So it's a classic case of third-party loss, pure economic loss. The dredge damaged OAR's pipeline, which caused Caltex damage. Traditionally held not to be available in negligence. Now, the court held that in damages for pure economic loss, they're recoverable in exceptional cases where the defendant had knowledge or the means of knowledge that a particular person, not merely a member of an unascertained class, would be likely to suffer economic loss as a consequence of their negligence. So that's what happened in this case. And the case followed the Headley-Byrne case in the United Kingdom, which was a case involving a client suing their banker for negligent advice. Again, a misstatement, no physical injury. And this was the first time in England that there was a claim for negligence upheld where there was no actual physical injury. Now, there's a statement by Justice Gibbs in this case which gives you the rationale of why the courts have limited the availability of negligence for claims for pure economic loss. And in a sense, he's talking about the proportionability of forcing a person to suffer or pay for the loss of an unascertained class of people for negligence. And he says that great loss might be suffered by tens of thousands of persons, but to require the wrongdoer to compensate all those who had suffered pecuniary loss would be to impose upon him a burden out of all proportion to his wrong. And he's talking about an officer on a ship colliding with a bridge, causing one side of a bay not to be able to get to work. And that was his example of why you wouldn't impose liability for pure economic loss on all people as a matter of course. And the High Court held that it had to be exceptional circumstances. Now that brings us to Bryan and Maloney, which is another quite famous case where the High Court held for the first time that a builder owed a duty in negligence to avoid defects in a works that would be suffered by, would cause loss to. Now, I was involved with this case, so I can tell you that that's a picture of the building. It's in Chatswood. You might have seen it if you've been to Chatswood. There was 2 strata plans in this building. The lower strata was a hotel, and the upper strata were residential apartments. Now, the residents had the ability to claim under the Home Building Act. They had the statutory warranties, so they were fine. That part of the case settled. The hotel, however, did not have that luxury. Being a business, being essentially a boarding house, there's an exemption out of the Home Building Act, so they couldn't sue. So they sued in negligence. Unfortunately, for the strata plan, because the original builder and developer had a relationship with a contract which included provisions for defect rectification, the High Court found that the original developer, Chelsea Apartments, was not vulnerable, and therefore there was no duty of care owed at all. First step, fail, no duty of care. And relying on Wilcox Street, the anterior step concept meant that the subsequent owners, who could have no greater claim than the original owner, also no duty of care, no duty of care owed. So this caused a bit of a stir, as you would imagine. Strata plan, through no fault of their own, formed after the building had been completed, had no way to sue for the defects. And that's the situation where people started calling for reform. And then a few other issues occurred. So between 2014 and 2020, when the Design and Building Practitioners Act was enacted, we had the lacrosse fire in Melbourne, which I'm not sure if you recall, was because of aluminium cladding on the building. So we had a first floor balcony person, had a cigarette, threw the cigarette into a trash can. The trash can caught alight, or the stuff in the trash can caught alight, caused a fire, lit the bottom of some aluminium cladding on the side of the building. And between the time that the cigarette caused the fire to the time that the fire reached the top of the building, it was 14 minutes. And it was about a 14-story building. So it took a minute per story to get from the bottom to the top. That's how dangerous this stuff is. That caused an investigation by the Victorian Building Authority, and I was involved with that investigation as well. And then Grenfell happened in London. So obviously that's a very tragic event, and it caused alarm bells to ring all over the world. We in New South Wales then got the Building Products Safety Act, and there was a national report in February 2018. And out of that report came the Design and Building Practitioners Act. So we can see that there are a number of causes for the Act, or a number of issues that the Act is designed to rectify. There's the negligence issue, duty of care. Specifically, duty of care has been found not to be owed in a number of circumstances. Got to fix that. There's the building products issue. And I'll show you why that comes into the Act shortly. But they were also after the products, the building products used on buildings. They wanted to make impose negligence on the manufacturers and the suppliers of building products specifically. So here you have Section 37 again. So that's what eventually came around, coming out of all of those issues. This is how they decided to fix it. Now, what's notable about this is the first 7 words: a person who carries out construction work. Seems like a fairly broad spectrum attack we've got going on here. What is a person who carries out construction work? How broad is that? Well, looking at what that means, we really have to work out what is construction work. The person who carries out construction work is carrying out something. What is it? Well, construction work means building work, design, manufacture or supply, and that's where we're talking about the Grenfell issue. That's why that comes into play. And supervising, coordinating, project managing, or otherwise having substantive control over any of that other work. Very broad. So it's a broad type of work that could be conducted. Building has the same meaning as Environmental Planning and Assessment Act. That just means any structure or any part of a structure, but not a mobile home. So again, very, very broad. And building work is defined to include residential building work. We don't really know what that means though. Is that residential building work only, or is that everything and specifically residential building work? We'll find out. Now, just to be sure, they've added this reference to the Building Product Safety Act, and a person who carries out construction work includes manufacturers or suppliers. Well, they've already said that, but they're just ramming that home. So that tells you how important the issue, the Grenfell issue, was in their minds at the time. So the first case that came to consider what this all means was Goodwin Street Developments. And that was a case of Justice Stevenson in the Supreme Court. And he's been the judicial officer who has decided pretty much all of these things. Now, the facts of the case were that there was a builder called DSD Builders, and he was represented in pretty much everything by a man called Mr. Daniel Roberts. Now, Mr. Roberts was not a director. He wasn't an employee. There was no obvious connection between him and the builder, but he negotiated the contract, he administered the contract on behalf of the builder, and he controlled the carrying out of the construction work. Now, as things often happen in the construction industry, the builder went into liquidation. Then there were defects discovered, and the developer tried to sue Mr. Roberts directly under the DBP Act as a person carrying out construction work. So no connection with the builder, but he was there all the time doing stuff. Can we sue him? Is he a person carrying out construction work? Now, the court, Justice Stevenson, focused on the part D of the definition, and he held that in looking at construction work as a whole, the definition of building work under section 36, which includes residential construction work, meant all building work. So it was the broader of those two choices. The definition of building, being the definition under the Environmental Planning and Assessment Act, was very broad and included all structures or any part of a structure, but not a mobile home. So that is exceptionally broad, as broad as possible, really. And he found that Mr. Roberts was a person who carried out construction work because he actually did the work. Regardless of his connections, he's the one who did it. So that's the start. It's actually doing the work that gives you who the person owes who owes the duty. Next case, Pathburn. So this is a direct quote from the judgment. And the facts are fairly complex, but not that important. Really, it's the judgment that's important. And similar to Goodwin Street, it's the determination of a person who's actually carrying out construction work that makes the important decision there. But Justice Stevenson goes further, and he starts with the however. A person can have substantive control over the carrying out of construction work, and that's that part D of the definition of construction work, notwithstanding the fact that at any particular moment in time, the person was not actually doing anything to cause the control to be exercised, provided the person had the ability and the power to control how the work was carried out. So what Stevenson is doing here is saying that the mere fact that a person has the ability to control work is enough. They owe a duty. Now, what pops to mind instantly is a director. a director of a building corporation. They have the ability, as the controlling mind of the corporation, to control that corporation and its activities. So this seems to indicate that a director would be covered. Foreman, they have the ability to control the work. Any person who has a general role of supervisory nature in construction work would be caught by this. So even if they're not actually doing it, they're still caught because they have the ability to do it. So they owe a duty of care. Backbone number 2. It's really a sort of a furthering of that concept. Here we have Stevenson talking again about a director and a nominated supervisor. And he said that this Mr. Obeid, who had the positions of sole director and controlling mind as in that sense, and also the nominated supervisor, it's a function really, he was in fact supervising, coordinating and project managing the carrying out of the building work. So this part D, having substantive control over the carrying out of any of the work, is very powerful. It broadens this definition to include pretty much anyone in a supervisory capacity at all. So how would this affect our cases that we looked at earlier? The case of multiplex, for example. Well, the builder did not owe the developer a duty of care because they had a contract and the developer was not vulnerable. They could look after themselves. And as a result of that, because of the anterior step principle, the builder did not owe subsequent owners a duty of care either. DBPA comes in under section 37. The builder is a person who carries out construction work. Automatically owes a duty of care to the owner and the subsequent owner. That's it. Problem solved. So far, so good. Looking at Wilcox Street, the engineer, CDG. Now, it did the foundations. Remember, there was a geotechnical report, said we should get it. Original owner said, no, don't get it. So there was no reliance, the court held, there was no reliance by the original trustee and no assumption of responsibility by CDG. And therefore, because of the anterior step issue, Wilcox Street, subsequent owner, no duty of care was owed to them either. Now we have section 37, automatically owed. Problem solved. CDG is a person who carries out construction work. They are a designer, an engineer. So that's part 2, part B of the definition of construction work. Preparation of regulated designs and other designs for building work. So they're caught. They owe an automatic duty to the owner and a subsequent owner. No problem. Sorted. What we've got though when we look at all of this is a very broad interpretation of a person who carries out construction work. It includes everybody from the director of any significant entity in the building and construction process, the directors of the building companies, the directors of the architect, the directors of the engineering companies, the directors of the project managers, and the architect, builder, project manager, engineers themselves as well, whether they're a corporate entity or an individual. You've got the employees who actually do construction work. They're exercising substantive control over the work, they're doing it, and they're doing construction work. So for both of those reasons, they're caught. Everybody from the top down to the bottom is covered. Everybody owes a duty of care. If you're a supplier and a manufacturer, your directors owe a duty of care. The people stocking the shelves in Bunnings owe a duty of care. If the materials that they stock are used on a building and construction site, there's a duty of care. They put the wrong nails in, something falls over, they could be liable. So you can see how what's being created by section 37 is the opposite of what Justice Gibb was saying in the Willemstead case, the Dredge Willemstead. We have a situation where an individual who can do something relatively minor could potentially be liable for something huge. And that's particularly the case if you have some sort of supervisory role, a foreman, for example. You could go to work one day, something could be constructed, and any time up to 10 years after the occupation certificate gets issued for that construction, you could be found to be liable for millions and millions of dollars of defects. So this is a very significant provision. The question arises though, well, I should say there are also further provisions in the Design and Building Practitioners Act which make this even more significant. Section 39 says you can't delegate the duty. Once you've got a duty, that's it. It sticks with you. You can't contract out, Section 42. That sort of follows from non-delegation really, but they state it clearly there. And 41.3, it's subject to the Civil Liability Act. And importantly, the proportionate liability provisions of that Act. So why that's important is because if you have an owner, say, of a multi-storey office tower where there are lots of defects, so you decide to sue. Let's say the builder's gone into liquidation, so you want to sue everyone you can. So you sue as many subcontractors as you can find. You sue the directors of the builder because they're covered. It doesn't matter if the builder's gone into liquidation, you can still go against the directors. You sue the architect. Let's just say you come up with a list of, say, 10 people to sue, and you sue those 10 people. What's the first thing that's going to happen when, say, the architect gets the list statement and the summons from the Supreme Court alleging that they have a duty of care and that they've breached that duty? Proportionate liability. They're going to try and point the finger to as many people as they can to try and defray that risk. So they'll say, well, yes, I might be liable, or if I am liable, but I was instructed by the original developer, so they're a concurrent wrongdoer. The builder was liable, so they're a concurrent wrongdoer. The subcontractors there, the foreman. And this is something that I'm currently doing. I've come up with a list of 18 for my client. So it's not hard to come up with people when you look. So you've got 10 defendants. Each of them, let's just say they come up with 10 concurrent wrongdoers each, which is fairly conservative. What would happen then is the plaintiff will have to consider, well, there's another 100 people. Should we sue them as well? Let's just say that they decide to sue 10. So now the original plaintiff is suing 20 people. And those 10 people get their summons and their list statement, and they say, well, let's go and see if we can point the finger at another 10 people each. And so then there's another 100. And you can see that the issues in the case will balloon very, very quickly. So the effect of this is that a case which was about a strata corporation trying to sue a builder and being unable to has now become a situation where a plaintiff can sue anyone they like, but those people can also identify and spread their risk to multiple people. The issues in the case will explode. The costs in the case will explode. The number of defendants in the case potentially can explode. And it's a very unsatisfactory situation, in my opinion. So is this what Parliament intended? So we have a look at the second reading speech. And this is Kevin Anderson, the Minister for Better Regulation and Innovation. And it seems to be pretty squarely aimed at Brookfield Multiplex, the decision. He talks about where there was uncertainty in establishing a statutory duty of care. He looks at owners' corporations in particular and makes sure that they get the ability to sue. And he talks about practitioners who need to accept responsibility for their work. So it seems to be, and this is all about Section 37, or that time 34, but became 37. It seems to be all about Brookfield Multiplex. So you've got the walnut, this issue that the Strata Corporation couldn't sue the builder, and they smashed it with a sledgehammer. Now they can sue anyone they like. The amendments also referred to Brookfield Multiplex. So it's pretty clear from the second reading speech that the intention of Parliament was to provide an avenue. And it seems that they've gone way beyond that. Now, that brings us to a case which I've been recently involved in called Borlas Constructions and Warrumbungle Shire Council. And this is the latest decision by Stevenson on this issue. We ran an argument in this case that Parliament could not have intended this to occur, and that there were two problems. Firstly, you've got the issue that Justice Gibb identified in the Dredge-Willemstead. You've got small people who are now liable for potentially very large problems, and that never intended when they went to work that they would be subject to this liability. And secondly, you've got the issue that litigation will explode and it becomes very difficult to manage once you raise one of these claims. So we took some solace from the statement of Justice Stevenson in Pathburn number 2, where he referred to the capacity of Mr. Obeid as the nominated supervisor. So he was acting in his own capacity. And we said, well, perhaps what Parliament really meant when they said a person carrying out construction work was a person acting in their own capacity carrying out construction work. So the builder, but not necessarily all their employees and not their directors. The architect, but again, not their employees or directors, etc., for all the different functions that are referred to in the definition of construction work: project managers, designers, suppliers, manufacturers. The principals of those particular functions, not their employees and not their directors. That would then at least sort of corral the potential number of people to a manageable extent and give the owners an opportunity to sue somebody. So we ran that, but unfortunately that did not, that was not accepted. And Justice Stevenson stated that the availability of the defined term practitioner meant that when Parliament chose the word person, they must have intended it to mean anyone. Now that's under appeal, so watch this space, and I won't say too much more about that, but that's the status where it currently is. So that's the background to it all. But what does it mean in practice? When you have to plead a claim for a breach of statutory duty of care, there are a number of things that you have to consider. So as things currently stand, the provisions, including Section 37, are subject to the Civil Liability Act, including 5B. So as a part of pleading the claim, you have to make sure you cover these things. You have to show that the risk was foreseeable, that it was not insignificant, and in the circumstances, a reasonable person in that person's position would have taken the precautions. So that's the precautions against the risk of harm. So really that's talking about the scope of the duty. What should they have done to avoid the harm? So you define the scope of the duty, and you've got to take care of all of those things. Law Act Developments was a case, again by Stevenson, that came out in this area where he basically said that. He said you have to identify the specific risks. Again, you're talking about precautions here, and the precautions that should have been taken to manage those risks. So really that's talking about 5B. It's not sufficient to simply assert a defect and allege the builder was required to take whatever precautions were needed to ensure that the defect not be present. So this is really the first time it sort of came up, and Stevenson said, no, this is inadequate. You have to plead this better. Section 5D of the Civil Liability Act is talking about causation. And there are two elements to that, and these also have to be included in your pleadings. That the negligence or the act that was done, which was in breach of the scope that you have identified, was a necessary condition of the occurrence of the harm. So in fact, it caused the damage. And there's a second thing, and that's appropriate, that the scope of the negligence person's liability extend to that harm. And that's something that you can look at in terms of reasonable foreseeability as well. So it could be appropriate that the person be liable for that particular harm because it was reasonably foreseeable, for example. But however you do it, you've got to show why it's appropriate for that person to be liable for that harm.
Which might save the shelf stacker at Bunnings.
Yes, it might. It might. And so as a backhand way of doing it. So yes, you're quite right, Richard. Even if you get the duty imposed, that doesn't necessarily mean you're going to get over the line. Yeah. You have to prove that they've firstly breached their duty, and then secondly, that they caused the harm, reasonable foreseeability or something like that. Now, what about pleading a defence? Well, as I've said, I think it would be a very good idea to try and identify as many people as possible as concurrent wrongdoers, as a defendant. In that way, you defray your risk. And it's really a free kick. Yes, you do have to prove the elements that you allege, so you can't just go wild, but you don't have to join them, so you won't be liable for their costs. So it does require some evidence, but at the same time, it does give you an opportunity to defray the potential losses. And to do that, you have to take care of a few things as well. You have to plead that it's an apportionable claim, that it's a claim arising from a failure to take reasonable care, and show why that is. Now, if you're being sued for a breach of Section 37, that's not too hard because that's the claim coming at you. And in relation to the concurrent wrongdoer, the person you identify has to have caused the damage or loss. That's fairly simple. Now, there's a well-known case of UCAC and of anti-developments by Justice Hammerschlag, and that's been relied on by the Court of Appeal. And he identifies here 3 elements that you are required to plead if you allege proportionate liability. He says that you have to show the existence of a particular person, and that was an issue because they didn't identify an individual specifically, they identified classes of people. You have to identify a particular person. You have to show what act or omission by that particular person caused the loss, and what is it that they did, that is the negligence, and a causal connection between that and the loss. Now, there's this. The next case is HSD Company and Massey Financial Management, and in this case, Rothman J found 3 elements that are slightly different, but I'll show you why I think they work together. But with Hammerschlag's case, but he says that you have to include the identity of the concurrent wrongdoer. That's the first element, the same as the UCAT case. Secondly, the basis of the cause of action. So that's really an additional element in my submission. So you have to identify the duty, the scope, and the breach if we're talking about a claim for breach of Section 37. So those 3 elements: duty, scope, and breach. And then finally, the damage and the causation. So if you synthesize, and finally, he says that you have to identify and plead these things as if you were pleading a statement of claim, really. So even as a defendant, you are still pleading these things as if you were making a claim. You're alleging a person as a concurrent wrongdoer. You have to particularize it and plead it in a way as if you're making a claim. And that's a similar statement from another case. So if you synthesize those 2 cases into a list of elements, firstly, you have to identify who it is that you say is a concurrent wrongdoer. Secondly, the scope of the duty and the precautions that they should have taken. Thirdly, what they did, the breach of the duty, which caused the negligence. And fourthly, the causal connection to the damage. And those are the elements that you have to plead as a defendant. But really, that also goes for the claimant. So because of the link between pleading as a defendant and pleading as a claimant. So coming now towards the back end of it, in terms of takeaways, once we've gone through all this and you realise that if you're a plaintiff and you're considering making a claim, when you've got proportionate liability and the potential to claim against anybody combined, it makes it quite a potentially very expensive exercise and may delay proceedings and expand proceedings beyond the scope of what you might originally thought you were doing. So I would say that you should be very cautious about making this claim. It's a claim which can explode your proceedings and make them grow to something which is far beyond what you anticipated. It can be very, very costly, very time consuming. It requires lots more evidence. It requires you to essentially plead against or potentially plead against multiple people or take account of defendants who are pointing the finger against multiple other people, and that can defray your claim. So you would only do it, I think, if you really didn't have another option. If you are going to plead it, you've got to satisfy the requirements of sections 5B and D of the Civil Liability Act and refer to those authorities that I just took you to. And if you're a defendant and you get stuck with one of these claims, then identify as many concurrent wrongdoers as you can, and you must plead as if you were a plaintiff. So, now we've got some time for questions. Does anyone have any questions?
Just before we do, I might just add one other point that might be borne in mind if you're acting for a defendant who's said to owe a duty under the Act. There may be cases where it's appropriate to seek to have that question determined separately and as a preliminary point. And I only raise that because I've got one such matter at the moment where I'm for a principal certifying authority who's but one of 7 named defendants, all of whom are said to owe a duty under the Act. And the argument against my fellow is that he exercised substantive control over the carrying out of the works, even though he didn't supervise, coordinate or project manage the works within the definition. So the issue is whether he exercised substantive control. And my client and the plaintiff has cooperated in framing a preliminary question that the court is prepared to entertain. I think the matter's in for mention tomorrow with a view to fixing a hearing date for it. But that might be attractive to a plaintiff in light of the point that Garth has raised about the burden that's put on a plaintiff by a defendant who names 100 other actors as concurrent wrongdoers. The plaintiff might have a keen interest in being spared the agony of having to contemplate joining all those people as defendants. They'd rather, if they can have their preliminary point, have their allegation of duty dealt with as a preliminary point. So we're just trying to agree some facts as to what the principal certifying authority did with a view to those facts governing the determination of the question whether that constitutes exercising substantive control or, quote, having substantive control over the carrying out of the work. So that might be something to bear in mind if you're unfortunate enough to be a defendant to one of these claims.
Watch this space.
Yeah, I think it's coming up. But I think it's in for mention tomorrow, and I think the hearing date will be given quite soon because it's only a one-day estimate. So.
And our matter, the Bullis Constructions one, is in for first directions in the Court of Appeal on the 17th. So we'll probably get a hearing date then, I would imagine. So yeah, there will be some more movement in this area fairly shortly.
I suppose, although I'm not sure to what extent it bears on this, but the new legislation that's being floated, there's people are probably aware of this building bill that's being promulgated, which calls for the repeal of the Home Building Act. But I'm not sure what implications it has, if any, for the operation of this Act.
Yeah, it doesn't directly address this particular provision, but there might be some movement there as well. So we'll have to wait and see, because they are looking at the building regulatory environment in general, and parts of the Design and Building Practitioner Act are considered by the new bill. So it may be that something is said about this particular provision as well. Certainly the department is aware of this issue, so we'll see if they do anything. I'm not sure. So,
Any questions from anybody?
Everyone. As a matter of pleading under this new act, and because of, as I understand it, Stevenson's judgment requires you to plead out a fair bid, is there any guidance on how we deal with that if you're dealing with a claim under that which has, you know, a series of defects for each defendant? So they might have 10 defects for each defendant that in theory carry 10 different duties and then breaches that you need to identify. Is there any guidance or suggestions on how we do that without blowing our pleadings into tomes and novels?
blow out your pleadings into a tome novel. It's really...
If you're for a plaintiff, you mean? If you're
well, for a plaintiff. So, I mean, the case might be you're pleading against an engineer or something, and you say, look, you've done 1, 2, 3, 4 things that are wrong. Each one might carry with it a different scope of duty or a different breach. There's no way to capture all that in an individual kind of global pleading of you owed a duty of care to, you know, to carry out all your works with due skill and care. You didn't because X, Y, Z.
I don't think there's a shortcut, and I think it's been ever thus, because at least since Justice Garling delivered this decision in Garza with a personal injury matter years ago, for how to plead the duty of care under the Civil Liability Act in tort in a personal injury matter.
Yes.
So I think these later decisions that have considered the pleading obligation in connection with this Act haven't changed the established law about the pleading obligation as it's established by Garza, and it's painstaking. You've got to address every element in the Civil Liability Act in 5B and 5C.
Mm-hmm.
Yep.
Yeah. Consider a very large spreadsheet. That's what I've seen.
Plead by way of schedule.
Yeah, exactly.
Plead,
yeah. A DBP schedule, for example, is something that I've seen done, which has 300 line items on it.
I'm assuming it's not been published on the New South Wales website, the court website, that we can all plagiarise it with.
No.
Very helpful.
No. But yeah, I think, and as Richard said, you have to deal with each of those elements, so it is quite time consuming. And again, I think it's another example of why this can be a bit of a burden and an oppressive burden on both plaintiffs and defendants. Once these claims are made, it just increases the workload exponentially. Yeah.
If there are no other questions, I might call it close. Thank you, Garth, for all your work. And the only other thing I'll do is note that Garth and I got here early and organised drinks over there. So let's adjourn.
Yeah.